Tarun is a professor of public law and legal theory at WADAM here in Oxford, and also a vice dean at our faculty. He's also a professor and future fellow at Melbourne Law School, and he specializes in legal theory, constitutional law, and discrimination law. Tarun, thank you very much for joining us today. You have the floor.
Thank you very much, Andreas and the JDG team for inviting me. If you see me sort of turning back and opening and closing my garden door, it's only because my puppy is changing her mind about whether she wants to be outside or inside. And sorry about the barking, I can't deal with it right now. So thank you all for turning up for this session. And I was just telling the conveners that this will hopefully be the final time I'm workshopping this paper before pinning it down. There are still sort of several loose ends that I'm not entirely sure of, but let's see how it goes. I would really appreciate feedback, particularly on the points that I highlight. So the paper is called the Guarantor branch, and it's an attempt to theorize what is increasingly being described as the fourth branch of the Constitution. Now, obviously, the fourth branch characterization is a placeholder because it's one of those areas of legal practice where practitioners have been far ahead of scholars and theorists in thinking about and using a particular concept. So my proposal is that the Guarantor branch is the right way to characterize and to understand this. I'm really sorry, just one more.
Sure.
I'm so sorry about this. Okay, so here is the idea that the last half century or so, certainly sort of around the same time, post Second World War, post the UDHR, alongside the proliferation of the birth of the human rights discourse and its proliferation in both in international law and in state constitutions, a different parallel development was the development of particular types of state institutions that simply did not fit the traditional tripartite division of state power between the executive, the legislature, and the judiciary. The paradigmatic example of this type of institution is the Electoral Commission that democracy after democracy constituted. The older democracies constituted through statute, but most of the newer democracies after the Second World War constituted through constitutions. But there are other institutions apart from constitutions that, apart from electoral commissions, that are arguably within this branch. There's a lot of debate on what is part of the fourth branch and what isn't part of the fourth branch for reasons that should become clear very soon. The broad consensus in, all the 4.5 scholars who are thinking about this in terms of the fourth branch is that electoral commissions and anti-corruption watchdogs, at least when they have constitutional status of some sort, are part of this branch. Other contenders include things like human rights commissions, central banks, knowledge institutions like statistics bureaus and census boards, information commissioners, auditors general, attorneys general, and more controversially, constitutional courts. So that's the universe of institutions that we are talking about. To distinguish it from another set of institutions which have also posed challenges to separation, the traditional separation of powers theory, these are, in fact, just to make everything more confusing, American scholars characterized this other set of institutions as the fourth branch and still talk about them as the fourth branch. These are the regulatory agencies that came about with the welfare state in the US, and it's assumed in this new literature that these two sets of bodies are significantly different, that this independent regulatory agencies, despite their independence from the political executive, is still very much part of the executive, whereas what are now being called, described as the fourth branch outside the US, are very much distinct from the executive. So that's the sort of factual background in which this paper is located. Now, the paper makes broadly three conceptual claims, or at least it presents three conditions which are presented as both necessary and sufficient for an institution to count as a guarantor branch institution. These conditions are, first, that the institution performs the function of guaranteeing a constitutional norm or an aspect thereof. And I'll come to this in some detail very shortly. The second, that the institution is a constitutional institution, by which I mean that it is legally or politically entrenched to some extent. And I'm not going to spend much time on it because this is very much a sort of a related but separate project on entrenchment. But suffice it to say that I use entrenchment, legal or political entrenchment, simply to mean that the process of constituting, changing, or abandoning the institution requires a different and more demanding set of rules than the ordinary rules in law and politics to make certain changes. So as long as those rules are different and more demanding, somewhat entrenched, the degree doesn't matter. It is a constitutional institution, broadly speaking. And the third claim, or the third condition, is that the institution has to be sufficiently independent of the constitutional actor or actors most likely to frustrate the norm this institution is supposed to guarantee. And more on that in a moment as well. So these three conditions, when satisfied, the claim in the paper is that the institution can be aptly characterized as a guarantor branch institution. An implication of this claim is that the mere function of the institution is not sufficient. So an electoral commission in one jurisdiction may well be part of the executive or the judicial branch, and in another jurisdiction will constitute the guarantor branch. So there is context is hugely relevant, and within the same jurisdiction, over time, the status of an institution can change. So given the criteria that I'll just explain, my view is that the Information Commission in India used to be a guarantor branch institution, but is now, after certain amendments made by the Modi government, is now simply a part of the executive branch. So let me start with the first condition, which is, what is the guarantor branch institution for? This is a functional analysis of the point of the guarantor branch institution. And by way of a preamble, I think that the point of constitutions, one way to think about what constitutions are for, is to see them as time management tools that polities use to deal with time. And time is a particularly difficult and challenging phenomenon for human beings, cursed as we are, or blessed, depending on your point of view, with the ability to imagine or remember time both in the past and the future. So we remember what happened, and we can imagine ourselves, and not just ourselves, but our communities, our polities, our states, well into the future. And because our well-being is deeply connected with both the memory and the possibilities, it creates anxieties within us. But while we have this consciousness about time, which spans our lifetimes and perhaps even beyond, at least with respect to future, we have no ability to change the past and limited abilities to control or manage the future. So I imagine constitutions as attempts to reduce certain types of future risks that polities imagine or foresee, and like to. By constitutions, I only mean constitutions that are intended to work, not facade constitutions, and at least in the sense that Sartori uses the term facade constitution. So, so guarantor institutions in this vision use the term guarantee in a very particular sense. So what I don't want to use is the private law sense of the idea for guarantee, which is that if a certain breach happens by a third party, say the borrower, then the guarantor steps in to make good of that breach. That's not the sense in which I'm using the term guarantee. I'm using it in the more colloquial sense of guarantee when we say, I can guarantee that I will be adequately provided for when I retire, right? Or things that we guarantee because we are reasonably certain of it happening or not happening in the future. And I use it in a conditional sense. So here is the idea of a constitutional guarantee in a formulaic sense, which is that a constitutional guarantee, in the sense that this paper uses it, is a conditional prediction. That is, that to sufficiently guarantee a constitutional norm or an aspect of a norm X, create an institution or a set of institution Y. Right? So if you want to guarantee that elections will be free and fair, you must have an effective and autonomous electoral commission, right? For example, and much will obviously depend on the setup and mechanism of the particular institution. So that is the idea of, that is the sense in which I'm using guarantee as a conditional prediction that certain norms will be respected, realized, honored, achieved, all the things that we do with ideals and norms. And it's an institutional guarantee. So guarantor institutions, obviously norms can be guaranteed for cultural reasons as well, but I'm not talking about those factors. I'm talking about institutional guarantees. Because certain institutions exist or are created, we can guarantee that this norm will exist. In this sense, the idea of a guarantee admits to degrees, and therefore the guarantee, in order to be credible, has to give a sufficient guarantee. Right? So because future is uncertain and human beings have limits to what they can guarantee, or human institutions have limits, the guarantee has to be sufficient in that, there's a credibility threshold that other actors in a constitutional negotiation will accept the institution is providing a credible guarantee only if it is capable of providing a sufficient guarantee that the norm will be realized. So obviously with the paradigmatic examples, you can see where this is going. Electoral commissions guarantee an aspect of democracy, which is the administration of free and fair elections. Anti-corruption watchdogs guarantee an aspect of probity in public life, which is, guarantee of corruption-free governance, at least at the higher echelons of power. There's a lot of detail here, borrowing historical digging into Kelson's ideas about the constitutional court. So the language of guarantor institutions is directly borrowed from Kelson, who in responding to Carl Schmitt's idea that the president guarantees the constitution, Kelson poses the challenge by saying that you simply cannot entrust the guaranteeing function in institutions who have both the motive and the ability to breach the very norm they are supposed to protect, right? So that's and there's an intellectual history of this idea in a very influential piece in 2000. Bruce Ackerman talks about the paper called The New Separation of Powers. Charles Fombad, in the South African context, has talked about the emergence of a fourth branch in what are called Chapter 9 institutions in South Africa. In Australia, A.J. Brown has discussed the emergence of the integrity branch as well. And Mark Tashnett has published 2 papers on what he's describing as institutions to protect democracy. And he has a forthcoming book on the same topic that is expected to be out in print later this year. So the idea is picking up steam and is gaining a lot of scholarly attention. Just a quick sort of point of digression from Mark, and this is a matter of emphasis, because in a footnote he acknowledges the point I'm about to make in one of his papers, which is that you can create a guarantor institution for any norm. It need not be a democratic norm. It can be. So the thought is that only those norms that are not self-enforcing need a guarantor. What are the self-enforcing norms? Self-enforcing norms are those norms that existing constitutional institutions in democratic contexts, at least, there will be the 3 traditional institutions. If they have both the ability and the incentives to abide by a particular norm, there is no need to create a separate guarantor institution. Guarantor institutions are only necessary when you either have incentives to frustrate a particular norm. So a conflict of interest, for example. So a classic case is asking the ruling party to administer elections, even though it still happens in the oldest democracy on earth. But that's, I think Kelson is right in saying that's a terrible idea. You can't give somebody who's so conflicted that power. Or there could be problems with capacity as well, where an institution is simply not capable of performing a certain function, even if it might have the will to, or no conflict. So the judiciary simply cannot administer elections around the world. Having said that, countries have experimented with it. In Bangladesh, had a period of about 10-15 years where as soon as elections were announced, the prime minister had to resign and the chief justice would take over as the caretaker prime minister of the country, and elections would be conducted under the leadership of the court, as it were, and that system was given up only in 2015. It's a terrible idea for separation of powers reasons and legitimacy of the judiciary, but there are good reasons to think that entrusting the judiciary to run elections is probably not a good idea, but it has been tried before. So that's the first idea, that we need, that guarantor institutions at least make theoretical sense in contexts where there is a constitutional norm that needs to be protected, that constitutions want to protect or realize or respect, but existing constitutional institutions are either going to be unwilling or unable to do so. It can be any norm from theocracy to, so the Iranian Council of Guardians is a very good example, in my view, of a guarantor branch institution that seeks to protect Islamic establishment in the state. You can think of guarantor branch institutions for a socialist regime, for example. So So I don't think Marx's emphasis that only democracy is needed is true, and even democracies may need guaranteeing norms that other than democracy, and probity is just one of them. So that's the first condition. I've already said that I'm not going to say anything about the constitutional character of these institutions. So you could have an electoral commission. It just does not enjoy either the legal or the political entrenchment. And by political entrenchment, I mean when there's broad consensus that between parties that the institution should not be changed by the ruling party alone, that the opposition must be involved in its reform. But that's so the function of the institution has to be to guarantee a constitutional norm or an aspect thereof, and it has to be a constitutional institution in the sense I just described. Is this a separate branch? Now here I borrow in the paper on Jeremy Waldron's idea of understanding the metaphor of branches in a constitutional state in terms, in functional terms. And I'm not going to revise it here because I'm assuming that most people in the group are familiar with this, with Waldron's idea. He himself draws upon both Locke and Kelsen. But the idea is that the tripartite separation of powers is meaningful in first dividing rulemaking from rule enforcement, and then further subdividing rule enforcement in terms of executive rule enforcement and judicial rule enforcement, and that division is functionally meaningful. What I borrow from that discussion in Waldron is the idea that the traditional division of separation of power, for all its sort of lack of clarity on the margins, is fundamentally a functional distinction. And I claim in the paper that the distinctiveness of guarantor branch institutions lies in the fact that they perform a distinctive function that cannot be reduced to any of the three traditional functions, and often requires a combination of several of these traditional functions within the same institution. There is a separate concern that Mark Tushnet mentioned in a workshop on a previous draft of this paper, which is something I'm formulating some views on, but I'm still not firm on it. The concern is that a branch surely has to have a measure of internal coherence, a sense of clear hierarchy in its internal institutional mechanism, etc., to be a branch. Right? So even if you concede that there are these constitutional institutions called guarantor institutions, what makes them a branch? My tentative thoughts on that question are that the idea of internal coherence and hierarchy in the traditional branches is overstated. Many countries have parallel judiciaries that exist alongside each other, like the constitutional court system and the appellate judicial system in South Africa, or several aspects of the executive where either the coherence or the hierarchy is missing, and we don't worry about them being a branch. And second, that at least in some jurisdictions like South Africa, it appears that at least, and this is very tentative, and I need a lot more work to make the empirical claims, so I'm making it as a hypothesis, that it's arguable that we're seeing a network effect where these branches, these institutions are beginning to see themselves as performing a common shared joint function and are supporting each other in particular ways. Another big question that okay, so this is the next section where the four general features. These are not necessarily sufficient conditions, but the four trends about these institutions that I think are worth noting. First is that they tend to be specialists rather than generalists. Right? So unlike the other three branches that perform plenary functions within their respective domains, guarantor branch institutions are specialists in that they focus on particular constitutional norms. This creates a debate over the status of constitutional courts, which in other regards look like guarantor institutions, but they perform the generalist function of protecting the Constitution rather than protecting a particular norm of the Constitution. But I don't have strong views on that, and I think there are good arguments on both sides, and I'm willing to bracket that for the purpose of this paper, but I invite any suggestions or thinking on what you think about the status of constitutional courts. Second, that unlike administrative agencies of the welfare state era, which share some of the features of these fourth branch institutions, constitutional guarantor branch institutions, while their functions are defined narrowly in the sense that they're not plenary, election management or corruption watchdog, etc. Within the subject matter, their functions tend to be defined at a higher level of abstraction. To give an example, an electoral commission is likely to have its functions described, at least when constitutionalized, in terms of administration of elections rather than enforcement of the provisions of the Election Act. Right? So that's quite typical of guarantor branch institutions, that within their narrow remit, they tend to have vague, broad, and abstract powers that they tend to develop over time themselves or in conversation with the higher judiciary. The third general feature of these institutions is their mode of reasoning, which is that unlike the other branches, so most of the other branches, because of their plenary character, make decisions, all things considered. This is true even of the judiciary, where, of course, certain types of reasons, no, I shouldn't say of course, right? At least in certain views of the task, adjudicatory task, certain reasons are not available to judges, or they can only approach those reasons in a certain way. But of the types of reasons that are available to judges, they must take all available factors into account and reason. And I've said in the paper that judicial decisions, in the sense, are bounded perspectively, right? That the judges must decide from the point of view of the law, but within this framework, within this perspective, decide according to law. They ought to nonetheless consider all relevant reasons before arriving at their judgment. So as generalist institutions, they must do all things considered modes of reasoning. Guarantor branch institutions, and this is again a hypothesis rather than it's an empirical claim but not tested in the paper, but put forth as a provocation, is that guarantor branch institutions tend to put their particular specialist norm that they are created to protect their raison d'etre front and center, and the balancing of that particular objective alongside other values is more marginal than plenary power bodies. Now, this is obviously a matter of degree, and it is true that they do take other concerns on board, but arguably less so than the other three traditional branches. And finally, another feature of them, at least when constitutionalized, guarantor branch institutions tend to be constituted and supervised in a multi-partisan rather than a unipartisan manner, typically through committees. So they occupy a space between law and politics, where unlike like judges, they enjoy a measure of independence from the political executive, but unlike judges, they are subject to regular oversight of politicians, just that it tends to be not just be politicians from the ruling party. I've spoken a lot, so I'll just briefly touch on the final idea and then finish it, which is that in terms of design imperatives, the final section of the paper talks about agency-like and trustee-like constitutional institutions. And these, again, not using them clearly in private law terms, but both agents and trustees have duties of loyalty to the principal and the beneficiary respectively, but only the agent with the duty to enforce the principal's will is simultaneously under the control of the principal, whereas the trustee characteristically must be independent of both the settlor and the beneficiary. And I make the case that guarantor branch institutions, when well designed, must be independent of the traditional constitutional actors, which are most likely to frustrate their constitutional purpose, and that this creates a deep tension between their autonomy on the one hand and their accountability, because the only thing that's worse than a partisan electoral commission is a partisan or captured electoral commission that has the reputation of being independent, because at least you can see a partisan captured election commission normally for what it is. But so if you create an independent guarantor branch institution that then ends up being captured anyway, it can legitimize undemocratic rule as if it was democratic. So I've said enough, and I think I'll shut up there and take your comments and criticisms. Thank you for your patience.
Thank you, Tarun, for this a very insightful presentation. We'll now have a 2-minute break, and when we come back, we'll move on to the Q&A section.